One young defendant walks into court facing a serious felony charge, and the judge is clearly concerned about his attitude. But then, something changes. The judge gives him a second chance that could completely change his future, while another defendant walks out with years behind bars. Stay with us, because the final moments reveal just how high the stakes really are.
And how you acted here in court and once you got to jail that day that's just a very immature way of handling things. And it also, of course, gives me a lot of concern on whether or not I should give you a probation. So I'm glad to hear that. Anything, Mr. Smith, before I sentence? All right, then, Mr. Rayleigh, I'm going to give you this opportunity today. I'm going to find that you previously entered your plea of guilty freely and voluntarily. This is cause number 25 DCCR 1482. Find sufficient evidence to find you guilty, but I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation. Well, not me, Brandon Louie. It was Mr. Smith. Okay. Okay. Hey, this is Mr. Nichols on Corbin Rayleigh. Good morning.
Good morning.
You're Corbin Rayleigh?
Yes, ma'am.
And Mr. Rayleigh was previously in court in cause number 25 DCCR 1482, entered a plea of guilty to the state jail felony offense of engaging in organized criminal activity. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, yeah. Yes, sir.
Any additions or corrections?
No, yeah. Not from this. Comments?
Go ahead.
Just that I want to tell the court that this is a completely different young man than I saw in court previously and at my office or over the phone. He's polite. He understands the proceedings that are going on. He understands that. I think the comments that he made to the probation department were before or immediately after going to jail. He understands now that what he did is a felony. He accepts responsibility for it. In talking with him this morning, he's like I said, he's a completely changed individual. I think he's going to do well on probation if he can keep this up.
That's good to hear, Mr. Rayleigh. You're very young, and the episode, you're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That is going to include entering and successfully completing the JCDI program, which is an outpatient treatment program to make sure you are clean and have all the tools to stay clean, as well as any type of recommended treatment for any mental health issues that might be going on as well. Okay, so you're required to do those things, whether you feel like you need them or not. It's all just so that I want you to be successful and this to be a turning point and you change your life. Okay. This is a great opportunity. You're young. You don't have a felony conviction on your record. And if you successfully complete this probation, at the end, the case is dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you don't follow through with treatment, you test positive for drugs, you don't go to appointments, whatever it is, you're going to be back in here. You could be convicted of the offense, so you'd be a convicted felon, and go to the state jail prison for between 6 months and up to 2 years. Do you understand?
Yes, ma'am.
I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You'll get out today. Probation will talk to you before you leave the courtroom, but the first thing you do is make sure you follow their instructions, go straight to probation, get everything started, and do well.
Yes, ma'am.
Okay. Good luck to you. Thank you, Mr. Robles. Ms. Holmes, you've got Frederick. Let's do Martin Fonseca Cardenas. Good morning. You are Eric Gibson.
Yes, ma'am.
And Mr. Gibson has 4 cases set for trial to begin with jury selection next Monday. And what is the announcement?
Your Honor, we're ready, except we did get new discovery on Friday. I got over 80 pages of medical records, and I'm definitely not through those yet. I mean, I might can be by the end of the week, or I will be if I have to be.
Okay.
But
Mr. Smith,
So it's ready.
are those things that you just received, or why was it so late?
We had issued a subpoena due taken to the hospital. It's name records or whatever, and for whatever reason they weren't delivered.
The last time we sent subpoenas out, they were delivered this time.
All right, well, since you got them, I mean, it was over a week and a half out, so I'm gonna number the case.
Okay.
Has there been any change as far as negotiations or anything like that that I need to take into consideration?
Okay.
Okay.
All right, so I'll number the cases this afternoon, today after docket. You guys will know the trial order this afternoon.
Okay,
All
thank
right,
you.
see you next week.
Plaintiffs will get there. They still get those to these things.
Good morning, sir. Are you Tajuan Mack?
Yes, ma'am.
And will your client waive a formal reading of the indictment in each case?
We will.
No, this has just been going on a long time, so I've got lots of pages to scroll through to get all the way back to the indictment. There it is. Mr. Mack, in cause number 24, DCCR 1046, you're charged with the state jail felony offense of criminally negligent homicide from March 10th of 2024. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
And then, let's see, in cause number 26, DCCR 0085, you're charged with a third-degree felony offense of bail jumping and failure to appear from December 15th of 2025. And how do you plead to that charge? And again, are you pleading guilty freely and voluntarily, and because you did what they charged you with? In both of those cases, I have here on the tablet and some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Stipley?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Mack is not competent?
There is no evidence.
All right, Mr. Mack, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your pleas. And cause number 24, DCCR 1046, find sufficient evidence to find you guilty, and at this time find you guilty of criminally negligent homicide. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 26, DCCR 0085, find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of bail jumping and failure to appear. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 2 cases will run concurrently, which means together at the same time. And I'm going to sign a dismissal as part of this agreement, and cause number 26, DCCR 0086. If you'll please print 1046 for me. I sent it to you, apparently didn't print. I'm going to hand you in each of your cases the trial court certifications that shows that these were agreements that I followed, so you did waive your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that will, you can talk with Ms. Giplin. All right? Good luck to you, sir. Thank you, ma'am.
Thank you. Yeah. See you on those.
Yes, ma'am. Good job.
2 very different outcomes, but one powerful reminder. In court, every decision can change a person's future. What would you have done in the judge's position? Let us know your thoughts in the comments. And if you want to see more real courtroom moments, unexpected sentences, and powerful judge decisions, subscribe to the channel and turn on notifications so you don't miss the next case.